Hi from Australia. I'm Dr. Deb Waterhouse-Watson, and I'm here to give you an overview of some key findings from my current research project, which is investigating the process of court reporting on criminal sexual assault trials involving Australian footballers. As part of that, I've conducted interviews with 17 current and former journalists at major Australian newspapers. When describing their role, most court reporters referred to the principle of open justice. That is, the idea that the court should be open and accessible to the public unless there's a pressing overriding reason why not. As one said, their role is to bring the court process to the public. It's about trying to explain how courts operate, to tell the story of specific trials and how justice is meted out. Another said, you're basically the eyes and ears of the public of the justice system. The court round is becoming an increasingly difficult one, as there are fewer and fewer court reporters. So, for example, the Gold Coast Bulletin only has one dedicated court reporter, and most news outlets are greatly reduced, so they might have only 2 to 3 court reporters across all 3 levels of court jurisdictions. For a very high-profile case, they can cover most days, but often it'll just be the first day and the sentencing that they can be there for, and sometimes not even for whole days, which court reporters acknowledged can cause problems with balance. There are much greater expectations and pressures than in the past, so journalists have to file stories constantly throughout the day rather than being able to send a final polished report at the end of the day. And many are expected to live tweet, so be posting everything that's said in the courtroom to Twitter as they go along. They're also having increasing difficulty in accessing important information relevant to the cases that they're covering, particularly for committal hearings in Victoria and Queensland, so those are preliminary hearings. Some journalists described having no idea what was going on and having to infer what was alleged, as the witness statements were not read out. And they acknowledge that stories might be unbalanced, as cross-examination focuses on what the defence is concerned with, and they often don't have access to the prosecution case. Many express frustration about this, that it actually inhibits them from reporting accurately. And this access to information, sometimes the process is difficult and complicated. There are financial barriers as it's becoming more and more expensive to access information, and particularly in some Victorian courts, suppression orders are more and more frequent. And it's becoming more difficult to challenge those suppression orders because of budget constraints in the newsrooms. Journalists are perplexed by this, as one said, it's in everyone's interest for us to get it right. Most described having a good relationship with their editors, but had also had problems with headlines, captions, and editorial rewriting, which sometimes conveyed the opposite of what they'd intended, and this caused some upset and anger in some court reporters. Fairness and accuracy in court stories is crucial in the interests of justice, and it takes time, knowledge, and experience, especially with victims of sexual crime and other vulnerable parties. Those journalists who did have a sophisticated understanding of how victim blame operates came to it themselves. It was never part of their court training or their journalism education. And reduced time is an issue. As one said, if you're reporting on something and the other stations are there, then you've got to get it on the web straight away. That can mean that maybe the deeper analysis or the better writing isn't there. There's also an issue of inexperience, as the turnover is quite high, but also journalists are often sent who have no experience with courts to cover an important case. And so there's a big gap between what the experienced reporters know and can do and the brand new ones. And so if an inexperienced reporter is trying to get their head around what's going on, it's going to be much harder. Some preliminary solutions for addressing these problems was, most journalists say they need more resources, which is unlikely, but some things that could be possible would be allowing journalists to cover fewer stories in more depth, using a newswire service rather than sending someone without any experience, allowing journalists to write their own headlines, as some Sydney journalists are able to do now, building up trust with the courts, so having a media liaison for each court in each state, so that the journalists in the court can communicate and understand each other's needs and wants better. Having fact sheets provided to journalists or equivalent, so something that outlines the case, has the spelling of all the parties' names and just what the charges are in all states. And introducing a media court committee in all major jurisdictions, as there already is in New South Wales. So I plan to produce, particularly for sexual assault, but also more generally, guidelines for fair reporting in the next 6 months, so look out for those. But if you're interested in more, look out for my book, which should be finished in the next year. Thank you.